My Christian appellate name is capital S, lowercase Tepehen, capital S, lowercase Mith.
Okay, so that would be a yes. Thank you. Deputy Sims. Now calling 24W003208A, the Township of Ypsilanti versus Stephen Cameron Nigel Smith. Deputy Sims, state your name for the record.
Deputy Sims.
Thank you. Okay, and Mr. Smith, you've already stated and spelled your name out. Thank you. Today is the date and time set for an informal hearing in this matter. What I have is a citation issued November 17th, 2024, that charges that on or about that date you did operate a motor vehicle on Holmes Road at or near Ford Boulevard. And when you were pulled over, you failed to disclose to the officer that you had a concealed.
This moment is key because the magistrate lays it out as plainly as possible. This isn't criminal, no jail time, no probation. Just a civil infraction and a fine. That's about as lenient as it gets when firearms are involved. But sovereign citizens don't see leniency. They see an opening to grandstand. Instead of realizing, hey, I can walk out with just a fine, Smith doubles down on pseudo-law. It's a reminder that these cases aren't about logic. They're about ego. Do you think Smith genuinely believes this wordplay protects him, or is it just a stalling tactic?
Having a window tint, I don't have that citation, which presumably means that it was paid. So, again, this is a civil infraction. There is no criminal penalty associated with this, no jail time, no probation. There is, however, a fine. Before we get started, Deputy Sims, was there anything that you wanted to say?
No, ma'am, I'm ready to proceed.
Mr. Smith, as you have likely heard already, you have three basic options when it comes to this citation, and these are your three options. You can accept responsibility, that is basically admit that you did not disclose per MCL 28.425F that you had a license to carry a concealed pistol, and that you did not present that immediately to the peace officer when you were pulled over. You can accept responsibility with an explanation, so the court can take into consideration any mitigating factors and potentially lessen or eliminate the fine. Finally, you can deny responsibility, that is, deny that you failed to disclose your CPL immediately, at which point we will proceed to the informal hearing. I will swear in both sides, take testimony, and make a decision based on preponderance of the evidence. Here
comes the word salad. Smith leans on capitalization theories to argue about his real identity. But in law, your obligations don't vanish because you switch fonts. Judges see this as legal theater, stalling, posturing, and wasting time. Every minute he spends spelling his name is a minute the court isn't resolving the actual charge. And that's why sovereign tactics always collapse. The judge has one job: apply the law to the facts. And the fact is, Smith didn't disclose his CPL when required. Everything else is noise. If you were in the gallery, would you laugh at this or cringe?
Okay, so if you are denying responsibility, then I'm going to swear you in and swear in the deputy, and I will take testimony from both sides. So, let me explain how this is going to work. After I have sworn you both in, I am going to take testimony from Deputy Sims first, because Deputy Sims is the officer in charge of issuing the citation. That means he's basically the plaintiff in this matter, okay? Once he has finished his testimony, which you are not to interrupt, it will be your turn to testify. He is not to interrupt you either. After I've heard the testimony from both sides, I will make a decision based on preponderance of the evidence. As I stated before, that is a 49% to 51% standard. So basically, whoever's testimony is slightly more persuasive. This is
where the magistrate shows real professionalism. She carefully explains how testimony works, the standard of proof, preponderance of evidence, and the fairness of the process. She even asks Smith if he comprehends, locking in his acknowledgement. That's smart because it prevents him from later claiming he didn't understand. Sovereign citizens thrive on claiming jurisdiction errors or misunderstandings. The judge is calmly closing every escape hatch. This is what makes courtroom breakdowns fascinating. The clash between structured legal order and chaotic pseudo-law arguments.
a criminal case. It is not beyond a reasonable doubt in this situation. So, do you comprehend everything that I just said?
I do comprehend.
Thank you. Okay, raise your right hand, Deputy Sims, and Mr. Smith, you will have to tell me when it's raised if you're not turning your camera on.
It's raised.
Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth to the best of your information, knowledge, and belief, Deputy Sims?
I do.
Mr. Smith?
Yes.
Thank you. Okay. Deputy Sims, you may proceed with your testimony.
On 11/17/2024, at about 3 a.m., my partner and I observed a black Ford Fusion. It was on Ford Boulevard. I believe it had just turned onto Ford Boulevard with tinted windows. Proceeded after the car. It turned into the gas station there on the corner, and we followed it into the gas station and proceeded towards one of the exits. Before it returned to the road, the driver, Mr. Smith, exited and began yelling at us. At that point in time, we activated our emergency lights and conducted the traffic stop there. We made contact with him, explained the reason that we had followed behind him, and when I approached the vehicle, I looked in the vehicle and I observed a firearm on the passenger seat. At no point in time during that did I hear I have a CPL until after the firearm was located. He was detained, his CPL was verified.
Here, Smith pivots to racial profiling. Now, that's a serious allegation in the right context, but here it doesn't hold water. Why? Because tinted windows. If officers couldn't see him through the tint, then they couldn't have known his race before pulling him over. That contradiction alone undercuts his argument. And while the DoorDash details make for an interesting story, they don't change the legal issue. Disclosure of a firearm isn't optional, it's immediate. By bringing up side arguments, Smith only distracts from the core fact. He didn't follow the law.
Damaged property or a victim under sworn oath. Also, I believe I was being racially profiled. I had been pulled over, which I did stop, and I was let go because I wasn't suspected of any crimes, just as I wasn't suspected of any crimes by him as well, as he mentioned. We had sat in the intersection, which I was in the middle of a DoorDash, and I wanted to get on my phone to see where I was at. When I looked away from my phone, I seen him, the officer, and another deputy, or whoever it may have been, an officer, also sitting in the middle intersection for about 30 seconds, maybe to even 60 seconds. So he could see me through my windshield. While I believe it was racial profiling, considering the area we were in, it wasn't the best area. So when I pulled, which I did use my turn signal, and it was a stop sign, or it was a light, a signal light. So when the light turned green, I turned right with my turn signal. I also turn signaled into the gas station, which I was going to stop to check my phone, because like I told the officer that had pulled me over 10 minutes before, which I'm sure he heard on the radio call, I was door dashing, which I had admitted to both of the officers. He called another officer in response to what he calls me pulling myself over. He never admitted to pulling me over. He said I pulled myself over. I got out the car to explain myself that I was door dashing and that I felt like I was being harassed because I was just previously pulled over. I did not have a firearm on person, and he didn't have a reason to suspect me of any crimes or try to search my vehicle. I was illegally searched on person without my disclosure. I told them I don't consent to any searches, and they were digging in my pockets. I have a legal license, and
The ruling is textbook fair. Smith is cleared of the window tint because the evidence isn't strong enough. That shows the court isn't out to get him, it's weighing facts honestly. But on the CPL disclosure, he's found responsible. And rightly so, the officer's testimony was straightforward and matched the statute. The penalty? A $500 fine and 6 months suspension of his CPL. For a firearm violation, that's light. Instead of appreciating the measured outcome, Smith keeps trying to argue, but the judge cuts it off. This is where pseudo-law collides with real consequences.
I feel like they assaulted me in a way. And after he figured out that I did have a CPL disclosure, which he never gave me time to disclose because it was not on my person. So I didn't feel the need to because I was not present in my motor carrier for him to be in any type of danger. After he sat me in the car, which I feel like I should not have been detained that way, for about 15 minutes, they let me be on my way with a citation, and I don't believe I deserve the citation. And he doesn't have any evidence of the situation. It's just a presumption with no material.
Does that conclude your testimony?
Yes.
And did you have any evidence or witnesses that you wanted to present?
I have evidence on my phone of me asking him, what their badge numbers was, which they didn't really want to disclose. So I had to look it up on the internet. I have a dash cam, but it was not running at the time.
So before we continue, I do want to apologize because I did actually have the equipment violation citation as well. That is for the window tint. So did you wish to address the window tint specifically?
That's just how the car came. I bought it that way, straight from Ford. So it's free.
In Michigan?
Yes.
Deputy Sims, since I don't think I specifically asked you about the tint either because I had misplaced this on my desk, do you wish to address the window tint?
Yes, ma'am. I'm sure you're aware that no vehicle that comes from the factory has front window tint on it. During his first testimony, he admitted to having window tint and said that we saw him through the windshield, which is not possible at night, but he admitted that there was tint.
May I add something?
You may.
There's they didn't test any window tint for any type of darkness issues or anything like that. It was just kind of an excuse because that wasn't the first reason that he told me that he pulled me over. It wasn't for window tint, and you can disclose that through the video of his own body cam. They said that they pulled me over because he presumed that I was trying to turn around in the parking lot or evade him, but I was door dashing like I told.
The officer's testimony continues to strengthen the state's case. Calm, consistent, and fact-based. Meanwhile, Smith's defense is riddled with contradictions and irrelevant tangents. Courts always compare credibility. Who sounds more believable? The officer describing events step by step, or the defendant bouncing between DoorDash, racial profiling, and capitalization theories? By this point, the outcome is obvious, but the court still hears him out, showing fairness even when the defense is weak.
To the B ticket, that is the equipment violation, basically having obstructed vision with window tint. At this point, the court is finding you not responsible for the window tint, Mr. Smith, because based on just the testimony today, I don't think there's enough established to confirm whether or not the window tint would have been in violation. Now, regarding the A citation, that being the failure to disclose the CPL, the court is finding you responsible in that matter, and that is, again, based on MCL 28.425F. Basically, an individual licensed under this act to carry a concealed pistol and who is carrying a concealed pistol and who is stopped by a peace officer shall immediately disclose to the peace officer that he or she is carrying a pistol concealed upon your person or in your vehicle.
May I add, please?
Well, no, because at this point I'm making my ruling, and the pistol was in the vehicle. I understand it doesn't sound like you were in the vehicle at this point, but you were engaged with the officer, and it was your responsibility as the person with the CPL to immediately disclose that you had a CPL and that there was a weapon in the vehicle. So you are being found responsible. Again, this is a civil infraction for first offense. There's a fine here of $500, and your license to carry concealed is being suspended for 6 months. Now, what I am going to say is that you do have the right to appeal my decision as the magistrate. If you do so within the next 7 days, the case will be reheard by the judge. So,
How do I appeal?
you would have to either consult with an attorney or you can talk to the clerks about getting the paperwork. I cannot give you legal advice. So,
Yeah, because I wasn't, as he stated before, sorry, I wasn't actually engaged in a
Switching to the bail hearing, we see another sovereign playbook page, rejecting a public defender and insisting on representing yourself. Now, representing yourself isn't illegal, but it's usually a disaster. Judges often warn defendants, you'll be held to the same standard as trained attorneys. And here you can already see the cracks. The defendant mixes emotional pleas, legal jargon, and conspiracy claims. Instead of focusing narrowly on bail conditions, he spins into narratives about past judges and paperwork. This undermines his credibility at the worst possible moment.
A bail hearing, appearances.
ABA Cecilia Martin.
To understand what are the public defender's office appearing on behalf of Mr. Robinson, who does appear by video from the Dane County Jail.
Why don't you speak on
A copy of the complaint in this matter.
It is a bail hearing. State's position on bail.
Thank you, Your Honor. The state is asking that the court increase cash bail in this case to the amount of $50,000 with all previous conditions to apply. The state is stipulating that any previously posted cash bail could apply to that amount. The defendant have already demonstrated an ability to post some amount of cash bail. He posted $3,000 in this case in late June. He then missed a court appearance. The court set cash bail at $7,500 while applying the previously posted $3,000 in August, and then reduced that amount back down to $3,000, applying the previous amount. So, in essence, allowing the defendant's release after he remained in custody. That release was in September. Just 1 month later, he missed court again. He has been out in warrant status for months and had to be extradited here at no small cost from the state. So for this reason, I'm asking all the state's recommendation.
Attorney Woodard.
Objection, Your Honor. I'm pro se in my case, so I don't know why that gentleman is standing there. And I want to speak on my own behalf because I am pro se in this matter.
Hold on one second.
Hold on, that's for you.
I have no objection, and that's how he wants to proceed. You're right, just so you know, you do indicate you do not want a public.
Here's another SovCit contradiction. He claims he didn't need to disclose because he wasn't in his vehicle. But the law doesn't care if you've stepped outside. Disclosure applies as soon as you're stopped and engaged by law enforcement. He also insists on no victim, no crime. But firearm disclosure laws exist to prevent danger before anyone gets hurt. That's the whole point. Sovereign citizens hate preventive laws because they don't fit their victim-only worldview. But public safety demands otherwise. His logic just doesn't hold up under scrutiny.
First and foremost, ma'am, I think it should be reinstated to what it originally was.
Hold on. Actually, I want to make sure you're capable of representing yourself, sir. It looks like you've done so in the past. How old are you, sir?
I'm 41 years of age, ma'am.
Do you read, write, and understand the English language?
Yes, I do, ma'am.
Have you had any drugs, alcohol,
and
or
legal degree. Yes,
have you had any drugs, alcohol, or medications that interfere with your thinking here today?
No, ma'am.
You fully understand everything I've asked you and everything that's going on, sir?
Yes, ma'am.
All right. What do you think I should do in regards to bail here today?
Well, first off, I want to object to what the prosecutor has said. First and foremost, it's only been one time that I allegedly failed to appear. First and foremost, everything that we filed is being pro se, standing in my own prior persona. And the last thing that I filed, ma'am, was a default judgment. And in this matter, the state has
Sir, we're here solely on bail. So what do you think should set your bail on here today? Please stick to the argument.
Well, ma'am, first and foremost, I think it should be reinstated because it's not right what the state is doing. She just sat up in open court and just lied and said I missed court multiple times. This is not true. When I was taken into custody, it's because the first time was because the judge that I went in front of, Mario White, jacked my bond up because I wouldn't answer his question. I refused to answer the questions that he wanted me to answer because it's my right. And I chose to remain silent and not answer what he wanted. So I didn't hide. I exercised my right. I filed my paperwork, and time again, the state has not responded to any of my filings. Had I been a licensed bar member, all of my filings would have been responded to. But since I am pro se in this matter, they have not awarded me or afforded me.
You're only here on bail here, sir. Only here on bail. Stay focused. What you want me to reinstate? Anything else in regards to bail?
I'm asking for my bond to be reinstated to what it originally was. I just lost my sister. I just lost my sister December 22nd. I have not had time to go with my family and grieve. I've been in custody since December 12th, and I'm currently in custody right now. So I'm asking for you to do the right thing and allow my bond to be reinstated. I did not bail jump. I didn't catch any new charges, ma'am. In this matter, no new charges. I didn't catch any new charges. And I'd appreciate it if the state didn't lie and say that I missed court multiple times, because this is not true. And then you're standing in court, in open court, lying under oath. You're a public servant. I'm a servant.
All right, sir. Focus. You've made your point, and I do see that you only missed court one time on this case, okay? So please continue. Anything else you want the court to consider in setting your bail?
I want the court to consider that I am pro se. I don't have the college education that she has. I don't have the ability to sit up and lie and try to tarnish her character in open court. I just pray that this court.
This case shows us the core problem with sovereign citizen defenses. They rely on confusion, wordplay, and emotion instead of facts and law. Smith walked into court with a chance to walk out with just a fine and a suspended license. Instead, he buried himself under pseudo-legal arguments and lost credibility at every step. The officer? Calm. The magistrate? Patient and fair. The outcome? Predictable. And the bail hearing only doubled down on the same strategy. More filings, more protests, less focus. The result is always the same. Real law wins, pseudo-law collapses. What do you think? Are sovereign citizens true believers in this ideology, or just people looking for excuses to dodge responsibility? If you found this breakdown as wild as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom drama and breakdowns.